Hey y'all, welcome to Crank That Whip, and on today I have the introduction for the administrative tree, and we'll go over Florida Statute 322.2615 and 322.2616.
The administrative tree, that's pretty long. So we're going to break that down to the admin tree, okay? We're going to go over this admin tree. Now, I worked at the Bureau of Administrative Reviews for 7 years. We were known for a lot of things, but we were mostly known for suspending folks' license if they got a DUI citation. Now, a lot of people would think that they got a DUI because they got a DUI citation, but really, they were administratively suspended. They didn't get a DUI at that point, although, you know, it's misunderstood. People always think they got a DUI when they get pulled over. No, you got an administrative suspension, baby. And the administrative suspension is brought to you by yours truly, Florida Statute 322.2615 and 322.2616, okay? Now, those are the two Florida statutes that govern when and how Florida drivers and drivers who are not from Florida are sanctioned for driving under the influence. Now, it's one or two things they can get. They can get driving with unlawful breath or blood alcohol level, 0.08 or above, or for refusal to submit to breath, urine, or blood test. Now, you may say, what's the difference between all the requests? The breath test should be requested initially. That should be the first test the officer asks if the person is still right there in his presence, still talking and standing up. Go ahead and ask for a breath test, baby. Now, if the officer suspects drugs, they will go. They should ask for a urine test. Urine detects the drugs. Okay, so if they are in the hospital, you know, getting checked out because there was a crash, or there's something going on with them where they can't blow, go ahead on and ask for a blood test at that time. So that's what the difference is between those requests. The breath should be the first thing they ask. If the person is still able to breathe properly, go ahead and ask for breath. Drugs, urine request. Incapacitated or not able to blow, something going on, COPD, whatever the case is, blood test. Okay, so the bar office is responsible for adding the administrative suspension to the driving records. Now, they add that with one or two things. With the DUI citation itself or the DUI packet, which includes the DUI citation. And drivers are either given this DUI citation, which is the notice of suspension, at the time of their arrest. They can apply for a hardship license, but it's based on their driving record and it's based on their offenses. How many offenses do they have previously for the same type of offense? That's going to hinder folks from getting approved if you have too many of the same sanction. The first time DUI offenders, they are the luckiest. They are able to get what's called a review waiver. A review waiver started 2013, I think it was, where drivers could go to sign up for DUI school right after they were arrested for DUI, contact the bar office, pay the $25 filing fee, and get a hardship license for $206.25. So they had to pay for the DUI school, they had to pay for the hearing, and then they had to pay for their hardship license. It was around $600, $530 or something like that. So these folks had money. If you got money, go ahead on and get your review waiver if it's your first time offense. Why not? Start back driving as soon as possible. The DUI citation that's for the adults is the 322.2615. Okay? Yeah, the adults are able to apply for the review waiver, while the minors are not. And the minors is the 322.2616. This statute is for under 21 drivers that get caught drinking alcohol and driving. So they, with the 322.2616, that statute is for the minors. The minors, they don't have the option of applying for the review waiver. They can apply for a hardship license after they serve their hard time, or they can apply for a hearing to fight the suspension. Those are their options. While the adults can do the review waiver, they can do the hardship after hard time, they can even do the formal or the informal to fight the suspension. So they got all the options, the adult citations. Okay, and the bar office is authorized in these two statutes to either add a 6-month suspension, a 1-year suspension, or 18-month suspension. The 6-month suspension is for driving with unlawful breath or blood alcohol level for a first-time offense. The 1-year suspension is for either driving with unlawful breath or blood alcohol level, the second or subsequent offense, and for refusal to submit to the breath, urine, or blood test, the first offense. BAR is also authorized, the Bureau of Administrative Reviews, to suspend for 18 months. 18 months is for the second refusal to submit to breath, urine, or blood test. What's the illegal limit, you say? 0.08. I can tell you one thing I learned was about the darn statutes, and especially 322.2615 and 322.2616. And why? Because that's what we dealt with on a daily basis. We had a few point suspensions thrown in there or HTO here and there, but we were on them do balls and them refusals like crazy. Okay? We had cabinets filled with suspensions for all over, I won't say the state of Florida, but for all over our region, our area in Tallahassee. There were tons and tons. So we dealt with that a lot. So I know those two statutes like the back of my hand. Long story short, okay, this is what happened. You were suspected of a DUI. After a DUI investigation, you get suspended for DUI. You blow .08 or above, you get your do ball. And there has to be 2 indicators of or DUI prior to the DUI investigation starting. There should be at least. The odor of alcoholic beverages, bloodshot eyes, slurred speech, confusing behavior, repeating the same questions. The list goes on and on. Officer needs at least 2 indicators before they can start that DUI investigation. And it's an even stronger case if they have the odor of alcoholic beverages and then 2 indicators additional to that odor itself. The reasonable suspicion initiates the DUI investigation. The DUI investigation is supposed to render more evidence of drunk driving and ultimately give probable cause for the DUI arrest. Under 21 drivers, the law enforcement officer does not have to do as much. All they have to do is just suspect this driver of being under 21, see an alcoholic beverage in the car. Boom. Let me get you to submit to this test. That's it. 0 tolerance in Florida for underage drinking and driving. Under 21 cases, instead of them being arrested for DUI, they can actually call a ride home. And the under 21 drivers, they are not arrested. They don't have to go to court. Their reinstatement fees are cheaper than the adult DUI citation. So they get the better deal with the case. But the only thing is they cannot apply for the review waiver. They cannot get their license back so easily with that hardship license immediately. Most of the underage 21 drivers are either speeding or spinning their tires. Those 2 things alone would get the officer attention. You don't want to cause attention on yourself, first off, when you're driving. And especially if you're doing something illegal. Now, what you can do to find out your options is contact the Bureau of Administrative Reviews. And you want to contact the Bureau of Administrative Reviews immediately, as soon as possible. I mean, you ain't gonna be able to do it immediately because you're gonna be in jail. But when you get out, when you get released, when you get your, bearings, when you get settled in, Go ahead on and look at your citation and call that bar office. Find out your options. See what you can do, which I already done told you. If it's your first time offense, you can do the review waiver. If you had a second or subsequent offense, you could apply for a hardship license if you're eligible. If you want to challenge the suspension, you could do that in any case. Any case, you could challenge the suspension. Heck, for any entry on your driving record, you can challenge or have a hearing. $25. Go ahead on and pay $25. Anything you want to argue about, the hearing officer will sit right there and let you argue it down. And then guess what? More than likely, unless it's an error, the entry is going to remain on your record, baby. But they don't stop you from paying that $25.
Thank you for watching Crank That Whip. Subscribe, follow, check me out.